A very warm welcome to Law Ki Bhara Khadi YouTube channel, and today we'll be discussing another very important case which was delivered by Delhi High Court recently. It's a San Nutrition Pvt Limited versus Arpit Mangal and others. So it's a very important case which talks about the tension that prevails between social media influencers and business entities. तो अगर आप क्लैट पीजी जुडिशियरी या किसी कॉम्पिटेटिव एग्जाम की तैयारी कर रहे हैं तो ये एक बहुत ही अच्छा जजमेंट है जो आप खुद पढ़ सकते हैं जो defamation, disparagement and other freedom of speech के बारे में बहुत अच्छे से explain करता है. So let's just dive into the brief facts of this case. So सबसे पहले let's understand that the parties involved in the suits were plaintiff was San Nutrition. It was a pharmaceutical company that was selling dietary supplements under the trademark of DC Doctor's Choice. And in this defendants we have there are six actually, and the defendant 1 to 4 are social media influencers, and then defendant 5 and 6 were actually the platform operators, which were Google, that was YouTube, and Meta, where was Instagram. So it was this judgment was basically about videos that were uploaded in relation to a product that was being sold by the plaintiff. So therefore the social media's companies were also made defendant in this particular suit. So I had actually briefly mentioned that this particular case was about the defendant posting YouTube videos and Instagram videos which alleged that the plaintiff's product, San Nutrition's ISO Pro, which was a protein-based product, was misleading and substandard in its nature. And after this video was published, the plaintiffs alleged that defamation, disparagement, trademark infringement, and unfair trade practices were being committed, and therefore the plaintiffs were entitled to relief. The plaintiffs also in their plaint mentioned that there was a sharp decline in sales and reputation damage following the publication of this video. So they had submitted in the court explicit and very detailed graphs regarding the fall in their sales after these videos were published. So basically जो केस रहा है वो ये है कि डिफेंडेंट्स ने कुछ यूट्यूब और इंस्टाग्राम की वीडियोस पब्लिश करी जिनमें उनने प्रोटीन बेस्ड जो प्रोडक्ट था प्लेंटिफ का उसके बारे में उनने कुछ बातें करी जिसमें उन्होंने कहा कि वो मिसलीडिंग था, सबस्टैंडर्ड था. ये वीडियोस जब पब्लिश हुई तो प्लेंटिफ ने ये बोला कि डेफमेशन, डिस्पैरेजमेंट, ट्रेडमार्क इन्फ्रिंजमेंट और अनफेयर ट्रेड प्रैक्टिसेस को यूज करा गया है और प्लेंटिफ को राहत मिलनी चाहिए. प्लेंटिफ ने इसके बाद ये भी बोला कि उनकी जो सेल्स थी उसमें भी काफी गिरावट आई और उनकी रेपुटेशन को भी काफी हानि पहुंची जैसे ही ये वीडियोस पब्लिक के सामने आए. So there were a number of videos that were in question in this particular suit. So in one of the videos, it was labeled that the product was a scam. In another video, there were satirical names used as "Doctors has no choice" in reference to the plaintiff's trademark. And in some of the videos, lab results were shown, and it showed that the plaintiff's product has misrepresented protein and carbohydrate content in their products. Apart from that, one video used a non-SSAI approved DY kit, while the others lab results were shown from the accredited labs, and some other lab reports were also submitted by the influencer, which were not there in the video but were submitted for the purpose of submitting them in the court. So basically, काफी सारे वीडियोस थे क्वेश्चन में इस पर्टिकुलर सूट में, और कुछ कुछ प्रोडक्ट वीडियो में इनके प्रोडक्ट को स्कैम बोला गया, किसी वीडियो में उनका सैटारिकल नेम यूज किया गया डॉक्टर हैज नो चॉइस करके. काफी जो उनकी वीडियोस थी उनमें लैब रिपोर्ट्स को यूज करके ये कहा गया कि जो प्रोटीन का उनका कंटेंट है और कार्बोहाइड्रेट कंटेंट है उनके जो प्रोडक्ट में वो मिसलीडिंग है, वो सही से नहीं बताया गया है पब्लिक को. इसके अलावा एक वीडियो में नॉन FSAI जो कि स्टैट्यूटरी बॉडी है उसकी अप्रूव किट नहीं यूज करी गई. बाकी जो अदर रिपोर्ट्स सबमिट करी गई थी वो जरूर accredited lab से थी. So ये थे, these were the major brief facts in this particular suit. Now to better understand the contention that were raised by both the parties, it would be great that if we could look at the plaintiff's argument and the defendant's argument and then the court's rationale. So the plaintiff's argument was that the videos contained false and misleading information. The second was that the use of their trademark in video titles and thumbnails amounted to unauthorized usage. So you must have noticed that when people are reviewing a product, they generally use the trademark, the product images in their particular YouTube or Instagram thumbnails. So this was considered to be unauthorized usage by the plaintiffs. And then they also alleged that the influencers were allegedly promoting competitors' products without disclosing affiliation. So in one of the videos, there was a comparison made with the plaintiff's product and other competitors' product in this regard. So basically plaintiffs का ये कहना था कि जो भी वीडियो उन्होंने बनाई गई थी वो एक फॉल्स और मिसलीडिंग इन्फॉर्मेशन दे रही थी. उनका जो ट्रेडमार्क यूज किया गया था वीडियो टाइटल्स और थंबनेल्स में वो अनऑथराइज तरीके से यूज किया गया था डिफेंडेंट द्वारा, क्योंकि वो वीडियो में नहीं ले सकते थे बिना परमिशन लिए पहले प्लेंटिफ से। और जो इन्फ्लुएंसर्स ने वीडियोस डाली थी वो कॉम्पिटिटर्स जो उनके थे, जो सेम ब्रांड और सेम लाइन ऑफ लाइक प्रोटीन के प्रोडक्ट्स बनाया करते थे, उनका प्रोडक्ट प्रमोट कर रहे थे और वो अपना एफिलिएशन उन कंपनीज के साथ नहीं बता रहे थे पब्लिक को। So now basically the defense, there were three major points of defense that were taken by the influencer. First was that they asserted that they had freedom of speech under Article 1A, and then they can talk freely about the products. Second was that they had used the truth and fair comment as defenses, that the videos were based on independent lab results. If you are aware about any basic knowledge about tort, you will understand that truth and fair comment are exception and defenses to the tort of defamation. And then the third basic thing was that they denied any malice or commercial affiliation influencing their reviews. So the claim that they were associated with any other competitors' parties or they were promoting some other brand, which was denied by the influencers in this particular case. So basically defense जो influencers ने ली थी उन्होंने ये बोला कि पहले तो हमारे पास फ्रीडम ऑफ स्पीच है, फिर ट्रुथ और फेयर कमेंट का उन्होंने डिफेंस यूज किया डेफेमेशन के खिलाफ, बिकॉज उनकी जो वीडियोस थी वो इंडिपेंडेंट लैब रिजल्ट्स उनने यूज करे थे उन पर्टिकुलर प्लेंटिफ के प्रोडक्ट का। एंड उन्होंने ये भी साफ साफ तौर पे डिनाई किया कि कोई भी मैलिस और कमर्शियल एफिलिएशन नहीं था उनके जो भी वो रिव्यू दे रहे थे प्लेंटिफ के प्रोडक्ट के जरिए। With regard to the suit that was filed by the plaintiff, they had claimed three basic relief. First was permanent injunction to refrain the defendants. Second was interim relief if they could be granted. And then third was trademark protection against unauthorized use. So basically तीन ये major relief sort करी थी plaintiff ने, जिसमें वो कहे थे कि permanent injunction होना चाहिए जिससे defendant और इस content को publish ना करें, ट्रेडमार्क का प्रोटेक्शन किया जाए उनका, और उनको इंटरिम रिलीफ दी जाए जिससे जो उनकी सेल्स गिरी जा रही हैं इन वीडियोस की वजह से वो उनमें कुछ लगाम लग सके। Now let us quickly look at the legal issue that was in this case. So I've taken the extract from the judgment itself. So the judge mentioned that this particular judgment and the issue dealt with freedom of speech and expression under Article 19 of the Constitution, with concerning defamatory and disparaging remarks made by social media influencers in respect of third party goods and services. So it highlighted the tensions between the social media influencers and commercial establishment, and also underscored the responsibility of the social media influencers and the big and important role that they play in consumer awareness. So before we dive into the court's rationale in this particular judgment, I will briefly tell you about the two major legal concepts that have been discussed in this particular judgment. So if you are a law student or if you have any interest in reading this in depth, you can read the judgment where they have explicitly mentioned and discussed these concepts in length regarding the exceptions as well. I'll just give you a brief overview of what is defamation. Defamation is recognized as an actionable tort under common law, and it's great to protect the reputation of a person. Now it talks about any oral or written statement which includes a video that lowers or tends to lower the reputation of a claimant is considered to be defamatory. तो अगर सिंपल शब्दों में इसे समझा जाए तो डेफेमेशन यही होता है कि अगर आप कुछ भी ऐसा स्टेटमेंट या ऐसा कुछ भी वीडियो बनाते हैं जो किसी इंसान की रेपुटेशन को खराब करती है या जिस तरह से लोग उसे देखते हैं उस चीज को इम्पैक्ट करती है, तो वो एक डेफेमेशन की कैटेगरी में आ सकता है। Now, disparagement is another tort. If we look at here, it's actually a tort which falls within the tort of malicious falsehood, and it basically seeks to protect the economic interests of the plaintiff as opposed to his reputation in the case of defamation. Now, basically, what happens in disparagement is that it involves making statement about the plaintiff's goods or services which are untrue and misleading and are made to influence the public in a manner not to buy the said goods or avail the services and cause economic disadvantage to the plaintiff. So basically disparagement एक ऐसा tort है जो जनरली लॉ स्कूल में नहीं पढ़ाया जाता है, बट ये tort of malicious falsehood के अंदर आता है, जिसमें बेसिकली अगर अपन बात करें तो डेफेमेशन में रेपुटेशन की बात की जाती है, बट डिस्पैरेजमेंट में आप ऐसा करते हो कि आप किसी इंसान का प्रोडक्ट लेते हो और उसके बारे में बहुत ऐसी ऐसी बातें बोली जाती हैं जो कि सही नहीं होती है, और इस वजह से ये होता है कि जो लोग आपकी बातें सुन रहे हैं वो इस तरह से हो जाते हैं कि वो प्रोडक्ट नहीं खरीदते हैं। अब वो प्रोडक्ट जो पहले ज्यादा बिक रहा था वो ऐसे नहीं बिकता है, और उसकी वजह से ये होता है कि जिस बंदे का वो प्रोडक्ट है उसको इकोनॉमिक हार्डशिप या उसकी वजह से उसको लॉसेस सफर करने पड़ते हैं, तो इसे डिस्पैरेजमेंट कहते हैं। So, after a careful examination of all the submissions made by the party, the High Court dismissed the plaintiff's application for interim injunction. And in this case, they discussed in length the concept of defamation and disparagement. तो जो डिफेंसेस थी जो इन्फ्लुएंसर्स ने दी थी उनको एक्सेप्ट करा था कोर्ट ने और उसके बाद उनने प्लेंटिफ को इंटरम इंजंक्शन जो है वो कर दिया था, डिनाई कर दिया था. अब नाउ लेट अस लुक एट व्हाट वाज द रैशनल behind the court's decision. So the rationale given by the court for this judgment was that truth and fair comment were a valid defense in this particular case because the lab reports that were given by the influencers were from accredited labs, and then there was no contrary evidence given by the plaintiff. Therefore, the defense of the truth stood the test. Second was that there was no prima facie defamation or disparagement. This was because of the following points: that the videos contained disclaimers, it did not use abusive language, and were not commercially motivated. Apart from that, the defendants also used satirical elements which actually fell within the scope of fair comment, which is another defense of defamation. सो बेसिकली कोर्ट ने काफी अच्छे से कंसिडर की सारी सबमिशन. उसके बाद हमने दो मेजर चीजें बोली. सबसे पहले बोला कि ट्रुथ और फेयर कमेंट जो था वो वैलिड डिफेंस थी बिकॉज जो भी लैब की रिपोर्ट्स दी गई थी डिफेंस द्वारा, मतलब जो भी इन्फ्लुएंसर द्वारा दी गई थी वो एक एक्रेडिटेड लैब से ली गई थी. उसके अलावा डेफमेशन और डिस्पैरेजमेंट का कोई ऐसा सबूत मिला नहीं क्योंकि वीडियोस में डिस्क्लेमर्स थे, कोई ऐसी अब्यूजिव लैंग्वेज यूज नहीं करी गई थी. सैटारिकल एलिमेंट्स यूज करना अलाउड है क्योंकि वो स्कोप ऑफ फेयर कमेंट में आता है, जो कि डेफमेशन का एक एक्सेप्शन है. Apart from this, the court also considered that there was no need for interim injunction, and this was based on the Bonnard principle, which I'll be discussing at the end of this video. So the reason the court took was that they should not restrain pre-trial speech unless the defense is bound to fail. Apart from that, pre-trial injunction, the court observed would have a chilling effect on free speech. The last thing that the court also mentioned was that the suit was not barred by limitation, which was a defense that was plea that was taken by the plaintiff. The court held that due to continuous online publication, the cause of action was held to be continuing, such that video जो है वो बार बार देखे जा रहे थे, and therefore there was a continuing cause of action. So these were the basic four rationale that was taken by the court to arrive at this judgment. So I discussed one of the principle, the Bonnard principle, and this is the extract that I've taken right from the judgment, which talks about the Bonnard principle. So the Bonnard principle was evolved in Bonnard versus Perryman case, and it basically talks about the caution that the courts should take while granting interim injunction. So it said that interim injunction should not be granted unless the defense set up by the defendant was bound to fail in trial. तो बेसिकली उनका कहने का मतलब यही था कि कोर्ट्स को बहुत ध्यान रखना चाहिए कि इंटरम इंजंक्शन देने से पहले उन्हें ये देखना चाहिए कि डिफेंस जो डिफेंडेंट द्वारा दी गई है वो अगर सस्टेन कर लेगी ट्रायल कोर्ट में या ट्रायल के दौरान, तो उस टाइम पे उनको इंटरम इंजंक्शन नहीं देना चाहिए. सो इसलिए उनका ये कहना था कि इंटरम इंजंक्शन देने से पहले बहुत सोच विचार करना चाहिए जिससे किसी भी पार्टी का राइट इफेक्ट नहीं हो. So with this, we come to the end of this particular case law. If you liked the video and if you enjoyed reading about this case, please do like, share and subscribe and share it with all your law student or any person who is curious about law. And don't forget to subscribe to Law Ki Bara Khadi. See you in the next video. Thank you.